Welcome to another edition of Business in the Know, an episode filled with answers to questions that most of us kind of have. Today, we're exploring the treacherous seeming lunacy of government regulations. Perhaps you're like me, busy running your business, trying to make a living, support your customers and staff, and the last thing you want to do is trying to figure out what next nightmare of legislation the government is throwing at us. Good news. My co-host Paul Benton has found a couple of good guy attorneys wearing white hats who are going to explain the intricacies of the ADA, how it affects websites, and maybe I can stop waking up in the middle of the night going, what now? What now? Paul Benton, welcome and good morning.
Hey, good morning, Mike. How are you? Well, everyone, we have two great guests today. The Carlin Law Firm, represented by Scott Carlin and Mike Carlin, are experts in ADA law. They have been involved in more than 2,500 ADA lawsuits in their career, and of those, 250 approximately concern the new phenomenon of ADA website litigation. Scott and Mike, welcome.
Thank you.
It's
morning to the other Mike and to Paul.
And gentlemen, every business owner wants to know, when did this become a thing and why did it become a thing? And let's start at that highest level.
Sure.
Can you start us out, Mike?
Yeah. So when did it become a thing? Well, if you take it historically back, the ADA was passed in 1991, the federal ADA, Americans with Disabilities Act. And most people think about the ADA like a parking space. Maybe it's done incorrectly, or you go into a bathroom at a business, it's missing grab bars and the handicap stall. And that's what they think of when talking about ADA lawsuits, having to do with access barriers. But in recent years, we've seen a slew of lawsuits having to do with access barriers on websites. And in fact, the ADA does protect websites and require that websites are reasonably accessible.
And so what kind of websites are affected here by the ADA? Is it every website? Who's at risk?
Not every website, but a good majority of them. So we're talking about websites that sell product or sell some sort of service, or are a companion informational website to a service or product. So maybe not your blogger who's reviewing movies and that's all he's doing, but if you have a dentist's office, that's a service, even though you're not selling a product on your website, you're affected. If you're e-commerce store, you're affected. If you sell a product in physical stores, maybe not online, but you have your website for all the information on the product, so like glass doors or something like that, that you wouldn't necessarily be ordering online, you are affected by this as well.
And I mean, business owners want to know, how at risk am I really? I mean, of all the lawsuits that are flying around in California, what percentage of those, there are millions of websites, how many ADA claims are there? How big of a risk is this?
Well, it's definitely a growing risk. Just by looking at the California filings, you see a fair amount, filed every day. It's not like once a month, it's on a daily basis that these cases are being filed. And not just in California. I mean, we're seeing filings in New York, Pennsylvania, and Florida.
And what is the, what would you say is, how many of those actually get to trial, and how many of them settle?
That's a good question. The vast majority, like any lawsuit, never make it to trial just because of the economics of litigation currently. So I would say almost all of them probably end up settling at some point along the path, but that pathway to settlement can be expensive depending on, are you picking up the phone and resolving it, or are you getting 95% of the way to trial and then you reach a resolution at that point in time?
And can we back up just a second? I'd love to get some help myself and help others understand, what are the dangers that we should be looking for? I get if I have a retail shop, has a step, has a skinny door, has no rails in the bathroom, okay, clear cut.
Sure.
I have a business that fits right in the, I mean, I sell some stuff. I'm not an online sales website, but I give information. I collect customer data to some extent. What am I doing wrong? What do they want me to do differently? I mean, and where's the biggest danger? And can I fix this before somebody comes after me?
Right. So yeah, there's two ways to look at it. What's the biggest danger versus what technically is required in terms of compliance on the website. And, our focus really is on what the vast majority of these lawsuits are actually about, whether there's probably additional accessibility that can be done on a website. The main things that we're seeing is what's called alternative text tagging. And I'll explain that in a second. And the other one is we're starting to see some having to do with closed captioning on video on websites. So the one that's a little more nuanced that someone might not understand is alternative text tagging. Just the quick overview is blind people, when they're using websites, tend to use what's called a screen reader, where it essentially reads out loud to you text on a website. But you can run into problems if things on the website aren't tagged with descriptors. The easiest example would be like a photograph. A photograph on a website that doesn't have alternative text tagging. The screen reader gets to it, doesn't really know what to say. So if you're in the shoes of the blind person, you can understand that, it's reading the text that's on the website, gets to the photo. Blind person does not know what the photo is of, and that's the problem. It doesn't have to only be with photos. You can have these errors having to do with your headers, your links, your buttons, but that's the problem, is the screen reader runs into things on the website that it does not understand. Then just flipping to what we're seeing in some closed captioning is for deaf individuals. If you have videos on your website, that's problematic if those videos don't have closed captioning.
Got it. That makes a lot of sense. And oddly, and I want to dig into some other risks and some solutions, oddly, text tagging makes life better for ADA compliance, for a sight impaired user, and for your search engine optimization. This is good. I feel good now. Suddenly there's something good going on here. I mean, this is just a good idea from the get-go. And now I know it's polite too. My mother would be thrilled. Tell us a little more about what we should be on the horizon looking for, and what happens if somebody knocks on my door, and most importantly, so there are lawyers who are seeking court action on this or settlement or something. Who's being harmed? What standing do they have? I mean, like, are there a bunch of people being terribly inconvenienced, and is that genuinely what's driving this, or what's happening here?
Scott, you want to address this one?
Yeah, well, there's a whole lot of questions. So let's just
pick one. Sorry about that.
Yeah, we'll just get started here. Look, as a practical matter, there's been a cottage industry developed among plaintiff lawyers in order to, from their point of view, help make the internet more accessible to people with disabilities, in particular visual disabilities, occasionally audio, and other types of disabilities. So with that, the Department of Justice was given the job of coming up with the rules and regulations to put into effect the Americans with Disabilities Act. And the idea was that businesses should make a reasonable accommodation for those who have disabilities. And so after many, many years of looking at it, the Department of Justice basically said, yes, websites, if they're involved in some type of commerce, either selling a good or service or supportive thereof, they need to do something, but they have not gotten to the point where they defined what that something is. The courts, by and large, have followed the regulatory body, and most jurisdictions have said websites should do something, we'll figure it out. Because of that, because of what I'll call a little bit of vagueness, more than a little bit of vagueness, it becomes easy for somebody to complain that you just didn't do enough. And so with that, the danger is if you aren't regularly studying what the courts are saying and what the Department of Justice is saying, and if you haven't seen a lot of cases, you're really quite a bit in the dark, so to speak. And so you come up with some ideas on your own, or your web developer comes up with some ideas like, well, we'll put a plugin in, that'll help a little bit. We'll put an accessibility statement up. We'll try to adhere as best we can to the WCAG, but to a great extent, you are kind of walking around in the dark, and that's the danger, is that you can end up with one of these lawsuits. There are law firms that are filing 300 a month, over 3,000 a year, and times that by 20 or 30 law firms that are doing this, your chances of getting hit can be considerable. We have one client's been hit 7 times, and they just were too busy to get around to doing it. So don't want to say who it is. On the other hand, there's been other clients that have kind of what I call cleaned up their site to make it more accessible, and they were not hit a second time. And we've done hundreds and hundreds and hundreds, as you said at the beginning. I think we're probably the largest in the U.S. at this point in terms of the number of cases, with about 2,500 in all, but half the cases coming into our office now are website cases. So I tell you that because the risk is extraordinarily real, and no matter what part of the country you might be in, the internet is a little bit like clouds and air. I mean, it goes everywhere. So you might think, well, I'm in Montana and we're not seeing a lot of cases filed in Montana. Well, maybe that's because you don't have a judge that is plaintiff friendly. And so somebody in California or New York will just file there because they want on the website, which happens to be, the business happens to be in Montana. So regardless of where you are, whether you're in Montana or Maine or Florida, somebody in New York or California or Western Pennsylvania is another place where there's a lot of filings. They're just filing regardless of where the business might be located. So the risk is real.
Scott, can I ask on that question? So you're saying that a small business that has presence only in California can be faced with showing up in court in another state?
Absolutely. We have those cases every single day. Now, how big is big? If somebody's doing $1 a year with New York, I can probably convince the plaintiff's lawyer who filed in New York, maybe New York will not entertain the lawsuit there. They should instead go, and if the person's in California, they would file in California instead. So if you are so small that you're only doing a couple of dollars or $500 or $1,000 with another state, I wouldn't be too concerned. Although you may get sued, we've had a lot of success in getting the lawyers to drop it, with the idea that the court would probably dismiss for lack of jurisdiction. But once you get over a certain amount of size, you're vulnerable virtually in every state.
And what's the exposure? So let's say that a California business gets sued because they sell $10,000 of goods in another state. What is the plaintiff on the other side actually asking for in terms of damages? And
Sure.
Can you help us understand that? I mean, what is the harm?
So under the federal ADA, they're entitled to 2 remedies. One is an injunctive order forcing you to fix the website. And the other is they're entitled to their attorney fees. And these attorney fees are only in favor of the plaintiff. So if defendant wins the case, he's not entitled to recover any of the money he spends defending the litigation. Flip of it is, the attorney on the plaintiff's end runs this thing all the way to trial. He can have quite a sum of attorney fees. So there's that. And then in California, additionally, if it's filed in California under the Unruh Act as well, there's a statutory penalty of $4,000 per visit for the violation. The bigger concern probably is the injunctive order and the attorney fees, because the injunctive order, depending what ultimately the plaintiff's attorney can convince the court of, could be fixing one minor thing on the website or a complete overhaul of the website, depending on what he convinces the court of. So that's a huge concern. And then obviously, if they win their attorney fees, those can be quite substantial.
But
And on the compliance issue, somebody might think, oh, well, the worst that'll happen is I got to pay a few dollars in attorney fees and the court will tell me to fix my website. No, because these court orders can be very draconian and they can essentially create an ongoing oversight. And what business wants somebody else to be looking over its shoulder every time they put a new product or image up on their site, wondering, gee whiz, am I within or outside this order that I've been ordered to do? It creates potential nightmare. So the threat of an injunction where there's an ongoing order that you have to do certain things to your website as administered by or overseen by either the court or the plaintiff is something that most of our clients do not want to tolerate.
do the attorneys on the other side, and I notice on your website you've listed a few to be worried about, do they actually have to have a plaintiff, or can they sue on behalf of a class? If they're suing 300, filing 300 a month, do they actually have 300 plaintiffs that they've lined up?
Usually they have 2 or 3 plaintiffs who say that they have been frequenting certain websites and found them to be non-compliant. Under the federal act, they could fall into the category. They have to have standing, so they would have to be somebody who's visually impaired, but they could also say that they're acting on behalf of, or they're complaining on behalf of others also. Under the Unruh Act, or under California, in order to get the extra penalty, you have to say that you actually had some encounter and had some difficulty yourself. That's peculiar to the California add-on component, so to speak. But under the federal act, you at least have to fall within the class of persons that you are acting as a tester for, which in the case of somebody using a screen reader would be somebody who is visually impaired using a screen reader.
And if I'm a plaintiff, how much money, is there an incentive for me to file these? How much money can a plaintiff actually net of the attorney collect?
Well, we do not have, how should I say it, access to the agreement between the plaintiff and the lawyer who files these lawsuits. The attorney, as Mike said, if they're looking to drag the case out, could be asking for quite a sum, because the ADA provides that the business person has to pay the plaintiff's lawyer's fees. And that is a huge incentive for plaintiff's firms to file these. As to the actual plaintiff themselves, in California, there is a statutory damage component. Mike mentioned the $4,000. And outside of in other states, there's generally not a damage component. It's very difficult to show a dollar amount. What would motivate a plaintiff to file a lot of these cases? I can't speak to that. All we know is that there's a ton of these being filed, thousands and thousands and thousands are being filed every day. We have a pretty good idea of some industries that tend to be more vulnerable than others. And it changes a bit with the economic situation. We used to see a lot of small restaurants being hit. They would throw their menus up and they would just use a PDF for their menu, which generally can't be read by a typical screen reader. But then after COVID, the small restaurants aren't doing so hot, so it would be hard to even collect from them if they're even in business. So we saw a shift to other types of businesses that tended to be doing a little bit better, less affected. So if anybody has a website out there, we've seen every business. We've seen dentist's office. We've seen eyeglass places, people that sell things that clip onto cell phones. I mean, you name it, we've seen it. Every business needs to be mindful of it. Make sure they're working with their web developers on some strategies to stay out of the crosshairs.
It sounds like there's a big minefield, and we can't quite divine the pure motives of some law firms who are pushing these lawsuits. So let's just focus on what we can do. Help me understand, how do I get to this place, right? Like I'm not trying to offend anybody. I don't want to get in a lawsuit. I'd like to be compliant. Probably the reason I'm not is not me personally. I'm very compliant, in case anyone's watching. How does this start? Do I wake up to a process server? Does somebody have to send me a note? Is there a claim? I mean, does the government say, hey, by the way, you need to fix these things, or are we right to spending money on and freaking out about lawsuits?
Well, that's a good question. Another form of that question, people ask us, don't they have to give us notice first before they can go with their guns blasting and cause a great deal of havoc for my business? The answer is absolutely not. There have been efforts in Congress to come up with a notice requirement. That does not exist currently. Maybe in a year or two, we'll see some legislative change, because all of our businesses say the same thing. If I would have just known, if they would have just told me, sure, I want to help as many people as possible. Gosh darn it, it's good for business. I mean, I don't want to exclude any customers. So they just said, just give us some notice. The plaintiffs have said, if we have to give them notice first, then they won't do anything. And so they particularly don't think that that's the way to go. They think that if there's a real penalty, if you don't do anything, that'll motivate people to actually do things. In any case, that's a discussion that's been going on for many, many years. We're hopeful we'll see some legislative change, but no notice is currently required. Similarly, people say, well, if I don't have a physical store, do I have to be compliant? Because people are reading some of the cases online. Unfortunately, that changes from jurisdiction to jurisdiction. So if you have a situation where you don't have a physical store, what's going to happen is that somebody in a jurisdiction or a state that doesn't require that connection will sue you there instead. There is no uniformity. The judges in New York are saying that it doesn't matter. A store is a store is a store, whether it's a physical place or not. The Ninth Circuit out west said, well, you need a physical connection. And so they've said the same thing down in Florida in the 11th Circuit. However, California State Court hasn't rendered an opinion on that particular point right now, and there's a difference at the federal level, so they're still filing in California State Court. So it's a mess. If you don't have a physical store right now, you're just as vulnerable as if you did have a physical store because of the split of opinion among the different judges. So the best thing to do is just simple, good old-fashioned prevention.
On that note, if we can, just a couple questions in closing. This has been very informative. What can a business owner do in prevention? For example, there's a product out there called UserWay. If you pop UserWay onto your website, how protected are you?
Not a lot. I'm getting not a lot. Is that what you're saying?
First off, it won't prevent a single lawsuit. So let's start with that. However, we are in the prevention business. We have 4 different things we would like to see the website owner do. We do believe that putting in a widget or a plugin like UserWay, we do think that is helpful. It's a cumulative approach. Not one thing in and of itself is going to create a bulletproof situation. The 4 things that need to be done is you need to address the WCAG compliance as the testers such as wave.webaim.org. When a tester goes on it, which is the most frequently used one, by the way, it will show errors, some of which are false positives, we know that, and some of which are true errors. And so one of the things we want to do is minimize or eliminate those type of errors, and only certain errors are the ones that are important. That's WCAG compliance, at least as it appears to the folks that are looking as the website being possibly non-compliant. They're using that in other testers. Second, an appropriate plugin. Some plugins should not be used because they actually alter the tester, and the testers are wise to it, and some of the plaintiffs firms are wise to it. So if they see certain plugins that interfere with the test, the typical tester, it actually can be work in reverse. So we got to be very careful about which plugins to use. Third thing is you need to have a proper accessibility statement. WCAG says all websites should have an accessibility statement that says what things on the website are available for those who have disabilities. And unfortunately, about 99% of the accessibility statements currently being used, we don't recommend. We think that it puts too much emphasis on the WCAG, and the courts have said that WCAG is not the law in the United States. It is something that you can do. It might be helpful, but it's not the law. So we don't recommend making your website have to adhere to a standard that is higher than what the courts are actually saying. And 99% of accessibility statements typically refer to a standard that is higher than what is required of them. We have a discussion of that on accessibilitystatements.com, which just is redirected to a page on our website. So it gives the background of why the existing accessibility statements can be problematic. The final thing that we like to address is a communication feature where somebody who is having difficulty can communicate with the owner what that difficulty may be. The typical communication feature we see on websites is generally insufficient to adhere to the suggestion by the Department of Justice. So we have recommendations that a client can adopt. Some of them don't want to go quite to the same level, for example, a 24/7 communication feature. But the more you do, the better you are, the less of a target you are.
Sounds like it sounds like a good plan. And thank you guys. In the last few seconds, I wanted to just ask, you've successfully taken the free-form panic out of this for me, and also made me realize that it's not something that I can just ignore like I like to do. So you've given us a great track to run on and a good sense of the dangers and precautions we can take. There are going to be a lot of people like me who want a little bit more help. You probably offer that sort of help on a number of different levels. What does that look like? How can folks get a hold of you? What's your preferred method of working with new clients? Are you taking a couple new clients? What's that look like?
Well, the
Sure.
first thing I want to say is that we approach this as a team approach. We don't expect the web developer to be reading court decisions and the Department of Justice regulations as they are changed from time to time. Nor do we expect web developers to be seeing what plaintiffs are looking for at the same level that we have, since we've seen hundreds and hundreds and hundreds of these lawsuits. We get a pretty good idea of what makes you a target. On the other hand, we're not going to do the coding. So the web developers are going to be part of that team. With regard to how we approach it, we usually like to have the owner, because there are owner decisions that need to be made. We like to have the owner and the either web developer or the key technical person at the company. We do a video conference. We put their website up. We go through it on the relevant pages. We show them how the testers work, what to add on, and where to put their focus. Sometimes a web developer will think they've got to do 4 times more than they actually need to do, and we can thin that down quite a bit. Depending upon the size of the project, usually it doesn't take very long. We're usually in and out of these things in a couple of weeks, unless there's a lawsuit involved, in which case it might take a bit longer, depending upon which law firm it is and what jurisdiction it was filed in. But with regard to the actual assistance on the website, if it's a typical size website, we may have 4 or 5 hours into it, and on the prevention side, work with the web developer, let them do their thing, and they'll circle back with us and ask us how's it going, what's it look like, you think we've done enough. It's pretty straightforward.
And I think it would be helpful to compare that to, you have a statistic, Mike, you shared. If you don't take this extra preventative care, what's the average settlement that we're seeing that business owners are facing?
Well, the important thing you got to remember, it depends on, at what point of the litigation these things get resolved. Because of the attorney fees clause, the longer this drags out, the better claim they have to a larger attorney fees. I mean, these guys are less likely to keep compromising down. They're going to actually be moving their numbers up in terms of compromise. If you nip it in the butt early, when the lawsuit comes down, maybe you're looking at something in, around $8,000, $9,000 to make this go away. But that's not everybody. I mean, that's a handful of lawsuits you see out there. Some are settling, higher, 15, 16, 20 grand. But again, this is early resolution. If you let these things drag out, you could be looking at substantially more, depending on when in the litigation you get it resolved.
Mike, tell us what's next.
So you got my attention with all this, and I think you got all of our attention. That's great. Scott Carlin, Mike Carlin, a big part of business.
Thank you.
Thank you.
I think it's been a pleasure. Thank you.
Thanks, guys. We'll see you next time for more trials and tribulations for businesses in the know.